Department of Community Development, staff. My name is Craig Miller, 711 East Front Street, Suite A. I am here, as most of you know, because I represent a client who is pursuing a bed and breakfast application in Clown County. This vacation rental ordinance, when first drafted, had attached to it a second section which dealt with additional regulations for bed and breakfasts. And there were many clauses in that second section which were similar to what you see in the ordinance which is now before you. And I wish to comment on the ordinance you have here, as I anticipate that type of ordinance will be coming forward in the future. And I think there are some things I'd like to say preliminarily so that they're in your minds when that one comes. A couple of comments about my comments, which are drafted, which are going to be made particularly from my point of view. And my point of view arises from having spent many, many years arguing about Clown County ordinances in front of boards of commissioners and judges and hearing examiners and on over how these ordinances are to be interpreted. And when it gets to the point of an interpretation being needed, a legal interpretation being needed, there are some principles that get applied that do not necessarily get applied when the ordinance is being looked at now. And I think those principles need to be kept in mind when you're looking at adopting the ordinance, because they will certainly make things easier when people are trying to administer the ordinance in the future. There are three principles which I think need to be followed. One is that the ordinance needs to be consistent. The words need to be the same every time they're used, and the same words need to be used every time they're used. The words need to be precise. You cannot use sloppy words. You can't use words that lawyers frequently call weasel words, or wishy-washy words, or words that have one or two or three interpretations. You need to pick the most particular word, the most correct word. The other thing is that you need to avoid extraneous language, because extraneous language will be seized upon as a way of saying, well, that's not what's really meant, because in this one place the ordinance says this something a little different, so it means something different than what you think it means. And so I think I would like to make a comment on those three subjects. I also want to make a comment on both of the ordinances which are before you, if I may, at this time. You really can, at least in my mind, separate the definitions from the operative portions of the ordinance. The definitions are very, very important, because the definitions define what the ordinance applies to. The first comment I want to make is in regard to subsection 1, which says, shall be operated in a way that will prevent unreasonable disturbances to area residents. It is a laudable sentiment. The language is, however, completely and utterly unenforceable in any reasonable manner. How do you, because, for example, your ordinance does not define unreasonable. It does not define what is a disturbance. How are you going to define that? Who is going to be defining that? Who is going to be enforcing that? The gentleman who just spoke before me, I think, rather eloquently expressed what the problem is with these ordinances, and I think what the problem that the county has faced and is going to continue to face in the future. I know that in the past few weeks you have been discussing with the Community Development Department the issue of enforcement of those ordinances. And it's all well and good to pass an ordinance, but the issue here is how do you enforce it? Because that's what you need, is how are you going to enforce this ordinance? There are already a multiplicity of laws in place that can be enforced in regards to unreasonable disturbances. You have disturbing the peace laws. You have all kinds of other laws. But how you enforce them is the issue. How do you enforce someone not parking on a septic tank? Somebody's got to go out there and enforce the ordinance. So the enforcement issues are ones that face you and face you very hard all over your ordinance set, but particularly with this one as well. That language is simply too vague. How do you enforce it? When do you enforce it? Is that the language that some poor police officer is going to be asked to enforce when he comes out in the middle of the night? Is he going to try to decide whether something's an unreasonable disturbance? Or how's that going to be enforced? So that language is, in my opinion, is simply too vague and really shouldn't be there. The second issue I want to talk about are your definition of the definitions. And in the definitions, the first definition I want to talk about is vacation rental. Vacation rental means a legally constructed single-family dwelling intended for occupancy of the entire dwelling, not rental of individual rooms, by any person group other than the primary owner for periods of 30 days or less. That sentence to me is extremely clear. The next phrase is extremely vague. Or is otherwise occupied or utilized on a transient basis. What is meant by that? Neither transient nor basis are defined. If what you're trying to do with this ordinance is reach vacation rentals, I think that the first phrase does in fact reach vacation rentals, and the next phrase is mere surplusage. Now, I may be wrong, there may be a specific reason for that, but I'm not seeing it on reading it. I then look at section 96, the new section 96, transient occupancy. Now, the interesting thing about transient occupancy is that transient occupancy does not appear anywhere in the substantive portion of the ordinance. The phrase that is used in the substantive portion of the ordinance is transient accommodations, not transient occupancy. So, when I talk about consistency and precision, that's what I'm talking about. I can easily see someone saying, well, I'm not a transient occupancy, I'm a transient accommodation. You need to get those terms consistent. The phrase then says, means occupancy of a lodging or facility or residence by any person other than the primary owner by concession, permit, right of access, license, gift, or other agreement for a period of 30 consecutive calendar days or less. Now, if you're trying to reach vacation rentals and exclusive occupancy or occupancy of the entire residence, transient occupancy also needs to include that concept in some way. Because otherwise, that phrase can be read to mean occupancy of a lodging. That could also easily mean a portion of a lodging, if it doesn't say exclusive. By concession, permit, right of access, license, gift. Gift is you get to occupy my residence without any consideration. There are lots and lots of occasions when people allow others to occupy their residences without consideration, without payment. Family, friends, someone who's injured. I can think of all kinds of circumstances. That language could be used to reach that scenario. So I don't know what transient occupancy adds to the definition of vacation rental. I think the definition of vacation rental, without the clause about otherwise occupied on a transient basis, gets you where the ordinance wants to go, which is dealing with vacation rentals of the whole residence. Subsection 3 of the main ordinance. Subsection 3A says maximum number of visitors allowed for vacation rental is dependent on the capacity of the septic system. That appears to me to be a statement of a limitation, which is you shall not use the septic system anymore, you shall not put a greater load on it than the system can handle by the number of people who reside in the house. While I understand subsection B, property owners are cautioned to avoid occupancies that exceed the design capacity. And I think Donnell referred to that as difficult to enforce. You know, somebody shows up with 15, so we're saying you're not supposed to exceed the limit, but you're cautioned not to exceed the limit. The difficulty that I see with having subsection B in there is that if you ever get to a situation in which you try to enforce it against somebody and say, well, you put 15 people in a system that was only designed to hold 8. Well, the immediate response of that person is going to be, well, you only cautioned me not to exceed the design capacity. So I didn't do anything wrong. I didn't break the law. The phrase is probably what you want to say to people because you can't monitor them at all times, but it causes a enforcement difficulty. And I don't know how you handle that, but there's an enforcement difficulty there because the second phrase pretty much cuts out any enforcement capability in regards to exceeding the septic capacity of the system. The next one that I wanted to comment on briefly goes both to the requirement for contracting for an on-site maintenance provider, but even more so to the contractor for refuse disposal. I do not know that you have the legal authority to compel someone to contract with a private contractor for removal of refuse. Generally speaking, municipalities can only require use of a public utility, and that public utility is owned and operated by them. And even then, generally, all that you can require is that a private property meets the standards of your public utility, pays the fees for the public utility, and if the property does not utilize the public utility, that's the choice of the property owner. You cannot tell a property owner that they have to contract with a private entity. It's a good idea, perhaps, but I think it exceeds your legal authority. So, in conclusion, I would suggest that the ordinance needs some reworking to bring it within the bounds of what is legal and the bounds of what is practical from an ordinance point of view. And with all respect to Danella, there is no such thing as just an ordinance, particularly from a lawyer's point of view. An ordinance is the law. It is black and white, and it is carved in stone as far as we're concerned, until such time as we can talk a judge into ruling it unconstitutional or throwing it out, or we can talk the legislature or you gentlemen into changing it. So putting things into an ordinance is a very large step that puts things very much into concrete. Thank you. I would be more than happy to answer any questions. Should there be any from either you or anyone else?
There are no questions. I do believe at one point we had representatives of the prosecuting attorney's office.
Yeah, I saw Mark leave.
Mark left. Is anybody from the prosecutor's office here? Okay, so Brian's still here. So, and one of the questions I'll ask at the end, I'm not sure if this ordinance has been reviewed by the prosecutor's office. It has. Mm-hmm. Oh, okay. So maybe we'll get their feedback on some of the points you raised from lawyer to lawyer.
Thank you.
I would also like to comment on code enforcement. Typically, what we've been doing with code enforcement is it's just by compliance. So I would say that the neighborhood really does set the tone as far as, you know, where the complaints are coming from. So if the neighborhood, if we get complaints, that's when we do code enforcement. We're not going out and seeking people out, so the neighborhood really sets the tone of complaints, and we're asking for another code enforcement officer.
I saw that you were, and I felt that was a very good.
Okay, thank you. So I don't think code enforcement is really it's not a problem.
Good.
That's why we have an ordinance and have it all in one place, so we can better do code enforcement if it's needed. I mean, this is really just a safety net, basically, for everybody.
You and I can talk at sometime about my experience with code enforcement in the past 10 years or so.
We're ramping it up. So.
I very much hope so,
Yes.
because it's not been as efficient as I believe it should have been.
Thank you.
Thank you.
Julie Smith.